on this. All righty. So we'll give Deborah a minute to pop in and we'll see. I'm sure we'll have a couple of other people join, but welcome. This is officially, for anybody watching the recording, this is the Ask Me Anything live for, what are we, June? Technically June 13th. There's Deborah. Welcome, Deborah. Okay, and I'm going to make sure that I open chat because some people show up a little late. Today's session, because I'm traveling and I'm working, I'm in and out of appointments today. This call will be a little bit shorter than normal, probably be about a half hour. So first come, first served. We'll get your questions all taken care of and answered. And then anybody else that with questions remaining before I click off can email me and we'll figure out another way to get those handled. Okay, so Steve, I think you were here first. Do you have any specific questions that I can help you with today? And then David, and then Deborah.
I guess one question that comes to mind, and maybe it's too broad to address now, but it has to do with copywriting, how to copyright and how to deal with other people's material.
Okay. Yeah, so some of the, and if you've got a specific scenario you want me to address, you're welcome to share more detail. The general, let me pop, I'm going to share a resource from my website that I'll pop in here. Give me just a second. I'll grab an article I wrote because, you know, the most basic place that people often start is like, what do you do to even post a copyright notice? Where do you post it? Is it required, right? All of that. So the answer is no, it's not required by law to post a copyright notice. The moment that something takes tangible form, like your creation takes tangible form, whether it's a photograph, an article, anything that you've created in your business, here's Diana, you own the copyright in that work, right? And the copyright rests with the individual. Now you can of course assign that right to a business or to anybody else, but it originally rests with the individual. And posting a copyright notice is not required by law to protect your rights in that work. Now, do I often encourage it? Absolutely. And that was why I was going to grab, let me just go to my blog, grab the article that I wrote about 3 things you can do to protect your work. Here we go. I'm just going to grab this and share the link. The reason that I recommend people get accustomed to using a copyright notice is because it does help to put people on notice that you are the owner of the work. And so many of my clients publish a ton of information online. They are publishing, you know, articles, videos, tutorials in different formats, all kinds of information. Maybe they've created an infographic to support a specific framework or idea that they've created. It's all sorts of ways that we create representations of our ideas and our work. But putting a notice on there, a copyright notice, is really helpful from the standpoint of somebody screen grabbing it, or like if you're a presenter and you've got a series of slides, having a little copyright notice at the bottom is helpful because people will take pictures of presentations or take screenshots if you're doing a lot of presenting online, and later maybe scrolling through those and forget, you know, what it was from or who created it. And so having your contact information on there in the form of a copyright notice, and that article will show you how I often do mine, is very helpful. You want to redirect people back to your work, back to your website, back to Googling your name and business online. So that is one way that you can use that notice. Now, if somebody infringes your work, is a copyright notice enough? No, the answer is no. The federal level registration is what allows you to recover attorney's fees and damages. And so without the registration, you have a very tough time with enforcement. And so that's where, you know, sharing a copyright notice is kind of the first step and a first level of protection, because it will let people know who the owner is. But in the event that there is actually infringement, it's not enough for you. The registration is what you need, because attorney's fees are cost prohibitive. People don't realize that it can prevent them from pursuing an infringement action because they cannot afford their own attorney's fees. So you can get recovery with a federal registration. So that's the big distinguishing factor, and super important that people look at the body of their work, because the other question I get is, well, do I have to get registrations for everything that I've created? The answer is no, but you should absolutely know how to prioritize what you have created so that you are focusing. And you're the expert on your content. When you meet with a client or you do a certain amount of the repetition of the work, what your core methodology is, your core framework, your core teachings, and you've probably got that somewhere, whether it's in a workbook or a series of articles or a video, or however you've prepared it. The question is asking yourself, what is the best representation of your ideas and your work so that you can seek protection around those. And keep in mind, and I always mention that in regards to copyrights, registration doesn't protect the idea, it protects your unique expression of the idea, right? So you do need to look at the body of your work and say, what are the best ways that I have expressed this idea and the best ways that I've encapsulated this, and seek protection over those core assets.
Okay, that's helpful.
Yeah. And then in regards to other people's work, the place that I usually start is that if you do not have express permission to use it in the way that you'd like to use it, don't use it. If you haven't created the work, because there's so much content out there. And I know people don't intend to get themselves in trouble. They don't intend to steal other people's work. But if you are taking other people's work, other people's ideas and concepts, other people's copy off their website or anything else, that, especially in the commercial context, it's one thing if you are a professor at a university, it's a different thing if you are a newscaster, right? There are exceptions to what's called, so there's copyright ownership and all of the federal copyright laws. And generally, like we talked about, copyright rests with the creator of the work, right? And when it comes to infringement, there are exceptions that are not considered infringement if you're using or referencing somebody else's work, but they're quite limited. And it's limited to, are you in the news? Is this a parody? Or, you're making light of a scenario to illustrate a point. Is it, or are you in the education system, right? Because there are exceptions if you are a professor or you're teaching inside of the educational system. If you're another business owner, and this is commercial context, very few exceptions, if any, apply in that context to taking somebody else's work. Because
so citing the source or identifying, not good enough.
Not enough, no. And even though in academia, that's what's taught, and to avoid plagiarism, that's a good practice in academia or education, totally different in the business context. Citing another source is not enough, because you still, without permission or an express license that you've paid for or somehow acquired, don't have permission to use it in that way.
Okay, thank you.
Great question, totally. Hope that helps. All right, I think David, you were next. How are you?
Pretty good. I just got back. Is my microphone working?
Yeah, I can hear you.
Yeah, I haven't used this for a while. See, I just got back from a conference in Florida, Clearwater Beach, Florida, for 3 days on how to learn how to be a speaker.
Oh, nice.
And to actually sell things from the stage or via webinar. And so it was a very expensive conference. And so it was very interesting to learn the techniques.
Yeah. Did you feel like you got some good value?
Oh, I absolutely think so, because I'm the engineer, right? And so I like, okay, this is what you put in the beginning of the presentation. This is what you do next. This is how people are going to remember this and that. And so the mathematical technique of it is something I can grab a hold of. I'm not the personality type who can just dance around on stage and convey my ideas.
You're not dancing on stage.
No, I'm not. Look, hey, one of the problems sometimes, and this is difficult, when I'm teaching, when someone's paid for a all-day conference that they've already paid for, there's nothing to sell, and you're actually teaching them the subject, is that sometimes I actually put myself to sleep when I'm talking. I'm so monotone. And so techniques, on being a better speaker are really kind of cool things to do with it and stuff. So I just got back from that like 9:30 last night. So trying to get caught up with everything. But if I could use my questions, Heather, to follow up with you on some of my, and then would you, if you have a chance, would you be able to send our recording that we did the last week on the website documents? You said you had recorded that session.
Oh, okay. Yeah, no, I can double check on that. It probably won't be until Wednesday. I'm traveling. You can see I'm in a weird little setting. I'm traveling. I'll be home tomorrow evening. So that's something I could check on Wednesday for you, David, because that's going to be on my bigger, like my desktop at home.
Yeah, I took notes when we were speaking, but I feel like I missed some of the items that I need Dawn and Lois to take care of
follow up
for
on.
me. Yeah,
I'll double check on that for you and I can Dropbox that over.
Yeah, and then if I could ask just a few follow-up questions to our meeting last week on the website package system. One was on the privacy policy that you have. In it, you have the insert Google Doc link, and that was specifically for a list of specific data processors that we currently work with. I don't recall in the Google Doc, are we just going to give the name of the company or a name and an email or a website, or what
question? Yeah, give them the website. So it's easiest to give a domain, because if they change their contact page or their contact information, I don't want you to be responsible for that. But if you give the name and then their website, at least they can click through to the website and find their contact information there.
And then one of the other documents that you had, what it was called, it had more a list of servicers that we use, like so it wasn't just payment processors like this one, but it was also like Active Campaign, REI Black Book, and those other things. With it, is that better suited in a Google Doc also, or because I think you had actually typed them up for me into the actual document?
Oh yeah, double check your email, because I think I sent you a completed version of that disclosure list. And yes, you would need companies. So for anybody listening, what we're talking about is under our current privacy regulations, you have the obligation to disclose any information processors. You're considered the information controller, the data controller, but we also have what are called data processors that help us process information in our business. So this could be anything from Infusionsoft, Active Campaign, ClickFunnels, PayPal, whatever payment processors you're using, Square, Stripe, right? All the ways that we connect the systems in our business, from our CRM to our payment processors to Google Forms, if you're doing intake questionnaires or anything, all of these components that are run by third-party companies, right, would need to be disclosed. The company and then the domain where somebody could click through, because what you want people to be able to access is the privacy practices of those companies as well, right? Because it's not just your business that is handling their data. So that's why we make this disclosure form. And it's why it does need to be a comprehensive list, David, not just payment processors, but all of those companies.
Yeah, and you did when when a person gets your package, you've got the thing all filled out for me because of the coaching. But in that other document, you listed 12 or 15 different people. Should that be put into a Google Doc or left inside of the actual document you put it in originally?
Oh, so yeah, you can take that document, which I saved as a docx, right, into your Google Drive, right? Because you can easily convert between a Word doc and a Google Drive doc. So yeah, you could just upload that into your Google Drive, grab the Google Drive link, right? Because your Google Drive is essentially hosting that document for you. And then, insert that link into your privacy policy once that document is live. And the reason I do that, you could do it a different way. So just in the same way that you upload your website terms and conditions, your privacy, etc., privacy policy, to your hosting site, right? To your website hosting site. You could do that as well with the other one. I just think it's easier with that data processor list to host it in a place like Google Drive where you can actively update it so that it's always current, right? So that's why for that particular document, I recommend a place like Google Drive so that you can always keep that list current. If you, for example, stop working with PayPal and you switch to Stripe, you would just jump into that list, remove PayPal off of the list of your data processors, update it with Stripe, and then you don't have to continually download and upload a new updated document. Does that make sense?
Yep, great. And then real quick, another question I had, you had said on the terms of purchase,
Mhm.
the I agree checkbox.
Yep.
And you said that you liked the scrolling version, I believe you said.
From a legal perspective, the courts like the scrolling. So when you guys have ever signed up for something, you probably recall that there's different ways that you can acknowledge the terms that apply to that purchase, right? So like iTunes style, you check the box, I have read and agree to the terms of purchase. And then you probably come across some sites that make you scroll, like you go through that big long scroll box and then you can check. The scroll box is, from a legal perspective, a more sound approach because you're literally showing them the terms in that box. I mean, most people are going to quickly scroll and not read it word by word, but you've given them a chance right there to check it out. If not, if you don't have the functionality to do that, then the second best thing is the checkbox where they still have to take an active role to acknowledge the terms. And then you've got a hyperlink right next to it. I have read and agree to the terms of purchase, and the link will take them to the document that will open on a new page, right? Or the terms on a
Yeah,
backend page of your
and
site.
so my question was, do you have service, who provides that kind of clickable thing where you have to scroll through? Is that, how do we
On the
find?
scrolling function, yeah, different providers will. You might just have to check with your tech team because it largely depends on the functionality capabilities between your order form or checkout system and your website, right? So whether it's ThriveCart, whether it's WooCommerce, like there's all different kind of back end plugins that people use on their websites for the kind of the checkout pages. Some of that can be custom coded. So I've worked with people who are working on a platform and they're like, you know what, we actually don't have that capability, but they create some custom CSS and convert an order form page with that capability through a little custom coding. So it's just one thing that you'll have to check on with your tech team, given the components that you're already using, find out if there's a way to do that. And if not, then that might be the point to explore, other alternatives. But there should be, most platforms these days recognize that there needs to be a terms option, a way to acknowledge those. And so if it's not readily accessible, the other thing you can do is contact that company and say, hey, how do we do this? They might have custom coders inside the company that can help you with that.
Okay, great. So it's a
Okay.
website guy.
Yeah,
Okay,
totally.
perfect. Okay, thank you.
Yeah, you're welcome. Great questions. All right. Okay, we've got 10 minutes, Deborah, and just in case you didn't hear it, I'm just doing a kind of a short mini call today because I'm traveling and I'm in and out of appointments. Deborah, have you got something that I can help you with today?
I do, and I hope that it's as easy as you're popping a link into the chat. I really appreciated David's detailed questions because one of my to-do things for today is to update and make more robust my legal agreement. I've always maintained that my fine print really ought to just fit on one page. I realize now that the world is more complex. And I have a fairly good template in general for that, but I'm wondering what you might have available from your, I'm going to call it your a la carte section. Of things that I might want to pay attention to. Thank you.
Totally. That's going to cover, first of all, everything that I just answered for David about the privacy policy, but it's also going to go through your website terms and conditions, the terms of purchase, any necessary disclaimers that you need on your site. So that's my website protection package. It's really designed to protect all those functions: selling, right? Selling things online, collecting data from people online, and then distributing information, including to people who don't buy things. Because I always tell people, just because it's free doesn't mean it's free of risk, right? So giving away information, giving away lead magnets, giving away things on your site doesn't mean there's no risk associated with that activity, which is why your website terms and conditions are really the foundation of your online business, from the standpoint of outlining all your general rules, protecting your intellectual property, having necessary disclaimers in place, right? Your privacy policy is all about the website visitor facing disclosures in regards to their information. Here's what we collect, here's how we collect it, here's how we keep it safe, here's how you can opt out, right? All those things. And then the final is the terms of purchase. Here's what we're selling and the terms and the details specific to those transactions, including what to do with our IP or what not to do with our intellectual property. All the disclaimers regarding the information that you are disclosing in the process of those services or that course or whatever it is that you're selling, as well as a bunch of other things that people often don't think about in the online digital space, like media, media consent and disclosures. If you're recording things, right, as part of a group, here's Cindy, you need a media disclaimer. Also, like if you're running group programs, you need the right to remove people from a group if they turn into somebody who's causing problems for you. So there's a whole, it is like a 9 to 10 page document that covers all the things that you need to cover in the running of a robust online business. So you can go check it out and read the descriptions. It'll show you what trainings live inside of there, what documents, and it should answer some additional questions for you.
Thank you. And are you going to make the recording from today's session available on the website?
Yes, I do. And let me grab that link for you. I publish these to my YouTube channel, so you can go watch any of the old ones, and I'll just pop that link in here, right here. And welcome to Cindy. Good to see you. There we go. That's my YouTube channel link. And it's right at the top, my Ask Me Anything Live series.
Okay.
So you'll see that they're published through last month. So you can go access any of the prior recordings.
Okay. I've taken notes while listening to you today was not an option, and I'm an expert note taker, but I really continue to absorb. Thank you so much. Really helpful.
You're welcome. Great to see you again, Deborah. All right, Diana and then Cindy. Diana, good to see you. How are you?
I am good. And I've been, the tech gremlins, I had to banish them from the house. I'm without my work computer, which has meant that I've been working on a prototype, mostly offline. I don't have any questions, but I had the time to pop in, and I always find something wonderful and useful. And I did send you a note about one of your newsletters.
Thank you. I saw that and I replied. Hopefully you got my reply.
I did not, but they're always read. But yes, I really love when you share those resources, and not only on social media, but in the newsletter. So
thank you.
As always.
No, I so appreciate that feedback. It's good to see you. Let me know anytime if you have a question, and double check, because I know we've had trouble with our emails before where my emails just don't, for whatever reason, get through to you. You might check junk. Otherwise, the other thing that I've had some clients do is actually call their host, because if my emails are not getting through, it's likely that there are some other emails that are not getting through to you. Sometimes you can have your security settings turned up a little bit too high, and so they are taking email and not even letting it into your inbox. That is not spam. Anyways, email is so complicated these days, but you might check on that if you feel like you've had trouble receiving anybody else's emails as well.
I changed my host. I went to a very expensive host.
Okay.
And am on my own private server now. So it's usually on the Google side if they through, yeah. But
all right,
I'll check.
Well, sorry, I did reply to your email. I'm sorry you didn't see it. All right, Cindy, good to see you. Do you have a question today? Were you just popping in to say hi? See if she's there. And if you can't, that's okay. I've got the chat open. We've got a couple more minutes. Today's just a little bit shorter session than normal because of my crazy schedule, but so happy to be able to pop in and say hi to folks. Any other questions that I can answer for anybody else on the call?
I just had Boink. So one of the things we're doing, I'm working on a prototype, is public domain images.
Hmm.
So they're in the public domain. I have an image that I want to use in a commercial product. It's from the 1900s.
Hmm.
So Library of Congress, it's in that database. It's identified as such. Is there anything else that needs to be done when it comes to that?
You
said-
know, yeah, I don't think so. Let me see. Just gonna. Yeah, they can be used. So images in the public domain can be used for personal and commercial purposes. Let's see. Right, yeah, and it just means that they're not any longer subject to copyright protection, or they may never have been. But
It was at one time.
at one time, yeah. So yeah, once they're in the public domain, you don't need to really do anything else.
And then when it comes to like using quotes, is
Mhm.
that fair use, or you have to go and get those permissions? I mean, where is that?
Yeah, that's a little tricky. It depends on the way that you are using them. So let me, and I know that I've researched this before. Quotes are usually copyright to the author, right? So what it means is, and it can be a little bit tricky because sometimes quotes are wrongly attributed, right? So you can get in trouble by attributing the wrong person when really it was somebody else that originated that quote. So it can take a bit of research, but then you do have to have, for any commercial purpose, express permission for the use of that quote, because just like, you write anything else, a chapter in a book, a paragraph in a, in a workshop, whatever, it's subject to copyright protection. And if you're not the author, you don't have the right to use it for a commercial purpose. So if you can find the true author of the quote, and they're especially if they're a live person, having written permission to use it is always the safest. Now, do I know people who have used quotes in a commercial manner and kind of gotten by with it? Sure. It really is up to, it's about your personal risk tolerance for that.
And in the past, I've done in my books, I got permissions. Some were paid, but most just were thrilled to have their work included. And so this is a little bit different. And I have found that where the quotes are wrongly attributed, because I've had to do the research to do that.
Totally.
Is there any other common mistake that's done when it comes to those types of quotes?
The quotes or copyrights? Yeah, I mean, generally, the most common mistake by far is using things on the internet without permission, right? Images, quotes, taking somebody else's title to their signature program or product, right? Just not doing enough research to understand the rights associated with something. One of the other really common mistakes is whether it's a quote or a phrase, somebody thinking like, oh, the domain's available, so it's available, I'm going to use it in my business. And they don't go research like at the USPTO level, where somebody might actually have a registered mark around that name or word or phrase, but they didn't check there. They just checked Google, right? That's not going to get you the level of research that you need, especially if you're putting a title on something, your business, your course, your book, right? Whatever it is, if you're choosing a title, do a fair amount of research and be sure to go check the USPTO database, because you don't want to choose a title and be using it in a commercial manner for something that already has a registered mark around it. So that's another really big pothole that people step into.
Okay, so then that question is, my understanding that book titles could not be copyrighted. Is that correct?
Book titles, yeah, they cannot be trademarked. They cannot be protected by trademark. But the reason I reference a book title is people will often name a book title like after their course or program name or whatever, or they're going to write a book and then create a program of the same name. And so there's a lot of overlap in the ways that we use these titles in our business. You just want to make sure you've also done the research to understand whether or not a registered mark exists around that phrase or title, so that you're not using it in a commercial manner. But you're correct, you cannot obtain trademark protection. Let's pretend that you write a book, you love the title, and you want to seek trademark protection, you can't. But you cannot trademark a book title. You can get a trademark registration for a book series. So like Rich Dad Poor Dad series, right? Like you can have a title that protects a series, but there has to be, you know, multiple books in that series, not just a single title book.
Yeah, I'm just, yeah, and there's so many like gray areas, it seems, as things have changed. Okay, thank you.
Yes, you're welcome. All right, great to see you all today. Any other questions?
Yeah, one quick one. How did you get a YouTube with your name after it?
You can go somewhere in your channel, you can go update it. So look into your settings, David, on your channel. You should be able to change that little the basically the appendage, right, of the URL.
You're supposed to have like 10,000 subscribers before you can do that.
Oops, well, I didn't.
Yeah. How long ago did you get your account?
I don't know. I mean, I've had it for a while, but I wasn't like an early adopter or anything. And I publish a few things there, but I'm not a massive publisher.
Yeah, that's not today. You can't do that. You have to have a lot of subscribers. People
really?
are grandfathered in. My wife has it, but
Oh,
that's because
wow.
she was in, 2 or 3 years ago.
Well, I feel so fancy now. Thanks for letting
Yeah,
me know that.
you do. Yeah.
All right. Any other questions?
No, thank you very much.
Yeah, you're welcome. And it changed. Got it. Diana's saying, yeah, the rules did change. I know they constantly change the rules on us. It's so annoying, right?
What about permission with someone who's deceased?
Yeah, that's a tough one because you have to find out essentially who owns the license to their content or the rights to any of their, like if they had a body of work that included copyrights, you have to trace that down. Did it transfer over to an estate? Did somebody else? It can be a trick.
Okay, thank you.
You're welcome. I know. All right. You guys have a great week. Pop into my email if you have any other questions, and we'll see you next time. Okay.
Thank you,
All right.
Heather.
Thanks, you guys. Bye-bye.